The 14B District Court is back in session. The court will call the case of the State of Michigan versus Joshua Gordonier. I'm not sure the prosecutor's back. She is. Case number 22S00943.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Joshua Gordonier.
Gordonier.
Thank you. All right, we're here today for a hearing in this particular matter. This is on a bond violation. The violation alleges that there was a tamper event on November 24th, 2023 at 1:31 a.m. when a tamper was detected by the SCRAM bracelet and lasted until November 24th, 2023 at 12:09 p.m. The total duration being 10 hours and 38 minutes. And that Judicial Services has confirmed that that was in fact a tamper. And we're having a hearing on this matter. If there's a finding that there was a bond violation in this case, then the defendant's bond will be revoked. All right. You ready to proceed, White?
Yes, Your Honor.
I just want to confirm there is no alcohol detected on that tamper, so it's just a tamper event only. From what I understand.
Is that correct, Ms. Levitt?
That's correct.
All right.
Mr. Levitt, has Mr. Gordonier been in?
One second.
I'm sorry.
You don't start. I believe Ms. McDuffie does.
Oh, I'm sorry. I'm tired.
Secondly, Mr. Levitt has to be sworn. So will you please call your first witness, Ms. McDuffie?
Thank you, Your Honor. I was actually going to start with Mr. Hayes because I want to understand the nature of the tamper itself, and then get to Mr. Levitt has more of the contract that was signed and what Mr. Gordonier, I'm sorry if I'm pronouncing it incorrectly, agreed to do or not do, but I want to get more information about the nature of the tamper first. So if I could call Mr. Hayes.
Thank you. Mr. Hayes, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may proceed.
Thank you, Your Honor. Does Mr. Hayes need to spell his name for the record?
No.
Okay, thank you. Mr. Hayes, so the judge just laid out what the nature or what the details of the tamper event are. You have provided myself, which I've also shared with the court and counsel, with the Judicial Services Group non-compliance report from the SCRAM system. Can you please explain to everyone present, I'm looking at page 4 of that report. We see a graph here that's got some red and blue lines on it. Can you please explain to us what exactly this shows?
Yes, so the graph on page 4 is the violation itself. It's the data points for that duration. On that graph, you're going to actually see 3 different colors. The red, which is an ambient temperature, which is a combination of the environment and the client's body temperature. The blue line is the IR sensor, which we use to identify tampering events such as this, which we actually call an obstruction. And then at the very bottom, you'll see a black line, which is the alcohol. In cases such as these, where there is a tamper present, the underlying issue is we can't identify whether alcohol was consumed during that time frame, because anytime something's placed in between the device and the client's leg, it does alter the readings depending on what's used. So while there's no alcohol present in the report, we cannot obviously verify whether alcohol was actually consumed and would have been detected if the obstruction was not present.
Thank you, Mr. Hayes. So I guess I should I guess I should clarify, it's not that no alcohol was detected, but it's rather that there was not the ability to detect alcohol during this event.
Correct. There was not alcohol detected. However, we still cannot verify whether alcohol would have been detected if the obstruction was not placed in between there for this 10-hour and 38-minute window that I'm testifying to.
Okay. And Mr. Hayes, how does Judicial Services Group go about understanding if that's possible, whether this is a matter of an obstruction being placed in the SCRAM tether device, or whether it's a loose fit or something insufficient for an accurate measurement?
So oftentimes we hear that tampers are caused by devices being on loosely. I've worn the device over 100 times myself. I've tested every theory possible in accidental tampering if the device is too loose. It's important to note that the device must be affixed to the ankle in a way that it has good contact with the skin. However, if the device is placed on too loose, two things. One, we will often see that IR sensor that I had referenced earlier, the blue line actually dip down, because the way that device works is it measures reflectivity. So it takes a beam of light from the SCRAM device, bounces that off the client's leg, and then measures that reflectivity as well as the distance. In preparation of today, I reviewed the history, and nothing looks to me like the device was too loose. While it can be loose, to my point, whatever would be accidentally fall under there if it was loose would have to remain there for a total duration of 10 hours and 38 minutes in this case. Anytime I've worn it, when I've tried to accidentally recreate it with pants, long johns, socks, any theory that I've heard, I've never been able to recreate it for the duration required for a confirmed tamper, let alone 10 hours and 38 minutes. And I can go into it as much detail as you'd like, or kind of just leave it at that. It's up to you.
Okay. I'm fine leaving it there. Defense counsel may have additional questions. Defense counsel or end of the court may have more questions, but I'm fine with that for now. So in terms of there being an obstruction, Mr. Hayes, can you explain to us what the temperature line is indicating in terms of where it starts and where it ends?
Yeah, so the temperature line we usually use to identify removal of the device. When I explained earlier, it's an ambient temperature. It's a combination of the client's body and the environment. If you take that device off of a client's leg and set it on a room with a room temperature of 72, let's say, it's not going to vary because there's no other outside sources for that. In this case, the IR or the temperature sensor is unremarkable. It really means nothing to me, especially with the time frame for this violation.
Okay. And so is there
I'm sorry, before you move on, I don't understand that last statement.
The temperature portion?
Yes.
Yes, Your Honor. So the device, when it's on the leg, it takes an ambient temperature. So it's a combination of the client's body as well as the environment. A good way to understand it, especially this violation occurs at 1:31 in the morning. Oftentimes at that case, what you'll see I work 8 to 5 Monday through Friday. So at that time, I would be getting in bed. When I've worn this device, I've used that theory of being in bed. Sometimes people sleep with fans on. Sometimes they sleep under the covers. Sometimes they move from under the covers. That differentiation is going to be very low compared to if I'm standing in my house and then I walk outside right now to get in my car. The temperature outside is much different than what my body and this room is. Oftentimes, if someone's in the same room, you'll see variations similar to what you see on this report because of that. If a client cut the device off or removed it and set it on their counter, that red line is going to stay straight because the room temperature is not changing. The room temperature is set to 75 degrees. I'm not moving it. My body is not changing that temperature. It's not going outside. It's sitting in one place. So often we use that temperature to identify removal.
So what you're testifying today is that the range that you see in this temperature is within normal ranges for it just being on him in the same place, potentially.
Absolutely. The temperature here varies from 75, 76 degrees up to 93, 94 degrees. It's exactly what we'd like or what we expect to see when a client's wearing it.
Gotcha.
And Mr. Hayes, so is there anything notable about the fact that the temperature remained within a normal range that you would expect to see versus that IR voltage changing? Is that further confirmation, I guess, for you that there is an obstruction?
It doesn't confirm nor deny it. What we're really looking for is that IR voltage, which is the blue line. That's what we're using to identify the confirmed tamper here.
Okay. And at the point where, what is it that indicates to you or confirms for you that this tamper event has ended?
So where that IR voltage returns to baseline. So when the client is affixed with the device takes a series of baseline readings to identify what the skin looks like to the SCRAM. In this case, on page 4, you will see that blue line go up, go down, go back up, stay up, go back down. What that tells us is that whatever is underneath that bracelet is being moved pretty much continuously for this 10-hour and 38-minute window, at which point it's finally removed at 12:09 p.m.
Okay. I don't have any further questions this time.
Ms. White.
You said that you know an obstruction was placed. How do you know this?
I can tell you that an obstruction is there. I cannot speak to the intent or how it was placed there.
Okay. And you said that the device must be affixed to the skin. But if it's too loose, it will measure reflexivity. Can you explain that again?
Yeah, so the device is affixed in a way that it has good contact with the skin. Oftentimes, clients who are placed on the SCRAM either lose weight, gain weight, pretty much any variation. If the device is too loose, that blue line, that IR sensor, will actually go down rather than go up. And the best way to explain this is if I take a flashlight on my phone and hold it up to my skin, the reflectivity in the distance is set. When I move it away, that light is going to be less bright, versus if something is placed in between there that's more reflective than my skin, that blue line is going to go up. So when it's loose and it's away from the body, it's less reflective, it's less bright. When something is placed in between there, it's more bright. So on page 4 of this report, if it was too loose, you would see that blue line under the baseline, which it is not here. And upon reviewing this client's previous history and history since this violation, there were no issues with the fit of the device.
Okay. You said you've worn this device in different situations. Have you worn it in bed?
Yes, I've worn the device over 100 different times, trying different theories and things that I've heard. I have worn it in bed, yes.
Have you worn it with work boots?
I have.
Okay. What is the percentage that the device messes up?
I'm not sure. Based on the criteria that we use to confirm a tamper, I can tell you there's peer-reviewed articles that found 0 false positives, but what the actual error rate is on the device on a singular reading rather than a totality, I'm not sure.
Okay. What was the peer review articles?
The most comprehensive is the National Highway and Transportation Safety Administration published, I believe it was a 76, 77-page article regarding the SCRAM device. That's the one where I was referencing. They found 0 false positives. And it speaks to the tamper technology somewhere along the lines of they believe it would be extremely difficult to get away with tampering based on the technology. The technology has been proven and it's been in existence since the early 50s. But I can't quote exactly the terminology, but that's the most comprehensive. There's 15 or 20 other peer-reviewed articles, but the most comprehensive is the one I just referenced.
You said it must be affixed to the skin. So if it's not affixed right, will it be loose? I mean, will there be a problem?
If there's a problem, oftentimes you see the problem constantly. I believe the defendant's been on for 136 days. I reviewed the data prior to. And again, I had said this earlier, and I'm going to reiterate it one more time. If the device is too loose on the leg, that still does not cause a tamper. When the device is affixed, one of the most common things you'll hear is socks, work boots, long johns. Gravity itself tells you that if something falls under there and the client moves their leg, it's going to remove itself. When I'm sitting down right now, my pant legs are up, my socks are down. If I move, it's going to continually do that. So for something to accidentally fall under there and then remain there for 10 hours and 38 minutes, I've never been able to recreate this for 3 hours, let alone 10 hours.
Okay, no more questions.
Any redirect based on those questions?
None from the people. I just asked if the court has any questions for Mr. Hayes.
I do. As I look at this report here that we've been provided, I'm looking at the IR voltage baseline. And you're telling me, so I have a couple questions. One is 0.025, is that the normal voltage baseline for everybody, or is that specific for Mr. Gordonier?
So the 0.025 that you're referencing is actually the alcohol. If you
That's the
look in the
alcohol?
back, correct. If you look in the background, very close to where that blue line is, you'll see a faint gray line in the background.
I don't have it in a color copy, to be honest. So 1 second, let me get it forwarded to me in an email.
Okay. Yes, there's a faint line in the background. There's actually 5 lines in the background going up. That first line is 1 volt. The
1
second line
second, I don't have a context to
Okay.
use it. I need to get the report. It takes a while to scan, unfortunately. Oh, I see. I don't have it open yet, but now I see along the line side, on the side there, it's tack percentage is on one side and temperature numbers are on another side. But my report doesn't show. Okay, it should be safe now. Okay. I got 2 things. All right, now I have blue, red, and black. And you're saying that there are 5 lines?
Yes, Your Honor, in the background, you'll see there's 5 lines that go the entire duration of this graph.
Yes.
It's the very top, so the very bottom gray line, right by where you see the IR sensor, that is 1 volt. The line above that is 2 volts, 3 volts, and then obviously the very top of the graph would be 5 volts.
I see.
And to answer the question, so his baseline prior to was 0.834 volts.
I see.
Everybody is somewhat different. I would say the majority of people fall between 0.7 and 0.9 volts. It's the reflectivity of your skin. So the shinier your skin is, generally the higher that voltage is. And in this case, his baseline prior to was 0.834 volts.
I
And
see.
at the highest level, which was at 9:37 a.m., that voltage goes to 1.56. So nearly twice as reflective as what his baseline is, but you can see that it constantly varies during the tamper.
I see. And so you believe that the tamper had, they're on this IR voltage line. They're, let's call them dots. Okay. So you believe that the tamper occurred where that third dot goes up? Is that the first place where you think that is that where you signify that is the 1:31 a.m. time? Is that the first tamper, or is it?
It's actually 4 after that. If you see, if you have the color copy in front of you, you will see there's a yellow shading.
Yes.
That yellow shading is the entire violation. The 0.3N is something being placed there for one reading and then removed again. And you'll see something similar to that towards the end of this report. However, because it's only a singular point, it's not considered a violation.
I see. And so does that hold true for the first point, the third dot that I was talking about? Because it's a singular point, it's not considered a violation?
Exactly. And on page 3 of that report, you'll see the criteria, which is 3 hours if alcohol is detected, 8 hours if it is not. So one singular point, and that's where a lot of the peer-reviewed articles speak to. The device is designed to give every benefit of the doubt to the wearer. We do allow for very small movement, but obviously nothing longer than 3 hours if alcohol is present, 8 hours if not.
Gotcha. I see. All right. Thank you. Any questions for the witness based on my questions?
None from the people.
Can you tell if, I know you said that, it normally doesn't go that long without something, but can you tell if a blanket or something got in between there while he was sleeping?
I cannot. I can tell you, even if the device is on loose, for something to end up under there, in my opinion, takes effort. To get under there and then effort to remain there for 10 hours and 38 minutes. So if it was a blanket, how it got there, I can't tell you, but that would imply that for the 10 hours and 38 minutes, there was zero movement once it was placed under there.
And in this case, we see something moving out and back in based on the baseline going back down to its original 0.834 number, correct?
Exactly, Your Honor.
Any further questions?
No, Your Honor.
None from the people.
Thank you. Thank you, Mr. Hayes. Is Mr. Hayes needed for the Beecham matter?
No, that's just between probation and CMH.
All right, thank you. All right, thank you, Mr. Hayes. You are free to leave at this point. We appreciate your testimony. Mr. Levitt, I believe is your next
Yes.
witness.
Yes,
Please
Your Honor.
raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may proceed, Ms. McDuffie.
Thank you, Mr. Levitt. Can you just briefly describe for us what role you have when you receive new defendants that come to you with an order for a SCRAM tether?
So I'm a supervision agent for Washtenaw County. When we get new referrals, we make sure everything is lined up. We give the conditions. We prepare the paperwork for the clients. When they come in, we give them all the packets to read through themselves, fill out initial sign-in date. And when they come back to our office, we kind of touch on the highlights, how the device works, the do's and don'ts. Have any questions, put the device on, make sure that the fit is good, that it's as comfortable as it can be. And they're free to go on their way with reporting duties once a week for the SCRAM tether for downloads.
And as part of that review, do you have them sign any sort of documentation to confirm that they understand what those terms are?
Yes, there's an agreement for each individual device, as well as some generic community corrections paperwork as well.
Okay, I'm looking at a document that you shared with us that I've also shared with the Court and Defense Counsel, which is called SCRAM Alcohol Monitoring System Agreement, which has this defendant's name on it, some initials, and some signatures and dates. So I want to just ask generally before I get into details here, when you review this information with the client, are they actually fitted with that SCRAM tether before they leave your presence?
Absolutely, yes.
Okay, and so do they have an indication at that time what that fit should be like? Good and bad fits and things like that.
Yes, we explain to every client that, most people don't expect it to be as tight as it needs to be because it doesn't need to maintain contact at all times with the skin. But we do put it on, have them stand up, walk around, put some weight on it. We do understand that muscles flex, so we don't want them to have it too tight, but also not too loose. If it tends to be too loose, sometimes it's even worse because it kind of hits their ankle bone. So there are some processes in place to make sure that it's as comfortable, like I said, as it can be. They're also told at any point during the duration that they're on it, they can come in if they think it's too loose, think it's too tight. If they want to switch ankles, we are more than accommodating to do those things to make it as least intrusive as we can for all clients.
So let me ask along those lines, have you or did you receive any communication from Mr. Gordinier that he had any issues with the fit of his tether?
Not to my recollection, no.
Okay, so as far as you know, no requests or no adjustments were made in his case for this grant. Okay, so when it comes to the proper fit, based on what you know about this and when you do fit clients, would it be possible for some sort of random object like a blanket or anything else to sort of fall into that space?
I mean, with as tight as the bracelet needs to be to function properly, would not happen by mistake. No,
Okay,
it does fit extremely tight.
okay. So, and if something were to be, well, let me just get back to the contract. So I'm looking at this document that we've received, and it looks like it was signed by Mr. Gordinier on August 29th of 2023.
That is correct.
And is the supervision agent signature right below his on that same date yours?
That is not mine. That is my partner. No.
Okay. So, so when you said that was your partner, were you personally the individual that actually reviewed these terms and fitted Mr. Gordinier with this tether?
For this exact one, I was not, no.
Okay. So let me then just be a little bit more general about some of the terms on here. So when it comes to the requirements, I'm looking at the first page of this contract, and it says they're not numbered, but let's see here. Which one is this? I guess the second one up from the bottom on the first page. There's a requirement that the defendant agree to clean around and underneath the bracelet every day. Does that requirement prevent any sort of likelihood, as far as you know, that there would be an issue with a recording in terms of tampers or anything else?
Not to my knowledge. I mean, if you're wiping it clean, drying it off, it wouldn't take more than a few seconds. So I've never had any issue or feedback on that something like that that's in the agreement that would cause the confirmed tamper.
Okay. And if defendants have any sort of issue with that tether, with the fit, do they have any instructions about what they're supposed to do in terms of contacts to report that?
Yeah, I mean, I've previously stated during installation, we let them know that if it's, if Mr. Hayes spoke to, people gain weight, lose weight, if they feel it's uncomfortable or loose or tight anyway, they don't have to come in. They're not limited to once a week. They can come in as much as they need to. And during all downloads, we do a general kind of quick little fit check to make sure that it's still where it needs to be in regards to the fitting. But
I don't believe I have any further questions for Agent Levitt at this time.
Thank you. Ms. White, your witness.
When Mr. Gordinier will come in, are you the only one who saw him?
No, there are several of us here that do the same exact thing. If I'm out of the office or tied up with another person or on another call, there are 4 or 5 of us here that kind of help each other out when the others are tied up. We try to get our assigned clients when we can, but no, I don't see all of my clients every single time they come in. No.
So you don't know if he came in several times because his tether was loose?
There's nothing documented in our system that would indicate that. We have to document every time somebody comes in that there was a successful download, if there were any alerts and any other additional information like a battery change or a fit adjustment, which is the terminology for what you're referring to. So there's no documentation that there was any fit adjusting done during the duration that he was.
Has there ever been a time when somebody forgot to put a note in?
Oh, I'm sure. Yeah. I mean, I can't speak to everybody else. I mean, it is possible. Okay. Yeah. People make mistakes. Sure.
Okay. If he had come in several times to get an adjustment, would that have affected anything or come off as a tamper? Do you know?
No, because in order to do that, we actually have to go on the computer system and essentially temporarily disable the detection so that those things actually do not occur.
Okay. All right, no more questions.
Thank you. Any redirect?
No, from the people.
Thank you. You are excused, Mr. Levitt. You may leave if you so choose. Any further witnesses from the people?
No, from the people.
All right. Ms. White, any witnesses from you?
No. Mr. Gardner, did you wish to speak?
I didn't tamper with it. This is my work.
Are we taking testimony now, Ms. White?
No, Your Honor. No, Your Honor, we're not.
Do you want me to say anything?
Can I speak with Mr. Gordon here briefly? Really brief.
Certainly. Can you get the translator in?
I didn't tamper with it.
All right. While Ms. White is back, we can continue with our hearing in the case of Mr. Joshua Gordonier, case number 22S00943.
Richmond, for the people.
Assistant Public Defender Sandra White on behalf of Joshua Gordonier.
All right, thank you. Ms. White, at this time, do you have any witnesses?
No, I do not, Your Honor.
All right, thank you. All right, any argument from either side? We'll
Your
start
Honor,
with you.
I'm sorry.
We'll start with Stephanie.
Okay. So Your Honor, I believe that the testimony should be considered to be credible by the court from Mr. John Hayes of Judicial Services Group, as well as Agent Levitt from Community Corrections. Mr. Hayes went into detail about exactly what the detailed noncompliance report shows in terms of the voltage, the temperature, and how exactly this device works with respect to a tamper. This, I think his explanation and his demonstration of what the reflectivity means in terms of how close that device is to the skin and how close it's supposed to be, and deviations from that are compelling. Mr. Hayes indicated in his testimony that this is an issue of an obstruction in this device, not a loose fit, not something hanging off, not something that's just sort of run of the mill. And I think the fact that the length of the tamper event is 10 plus hours is probably the biggest indicator here that something took place that was not acceptable in terms of how that device is supposed to operate. There was basically no room left for some sort of accidental scenario. While Mr. Hayes obviously cannot, there's not a camera on that device, he can't see exactly what's happening, but this did not appear to be a case of something like a loose blanket getting in the way. That tether is supposed to fit very firmly against the skin. And had something been there, he indicated that at some point gravity would have dealt with it. It wouldn't have been able to stay there for 10 hours. And the fluctuations that we see in that report indicate that this was not something that consistently stayed in the same position for that time. Agent Levitt, his testimony also included the fact that clients are given very specific instructions about the care of that device and how it should be used and how it should fit. They're more than happy to address any adjustments. The people, as well as Community Corrections, don't have any information regarding any requests to adjust that device, fits that were a problem or uncomfortable. And I think most importantly, the documentation between all the agents at Community Corrections should be consistent. The same person is not going to necessarily be there when they come in, but I don't think there's an opportunity for an oops where somebody didn't leave a note and this sort of incident would occur, escaping detection. This is not, based on Mr. Hayes' testimony, it doesn't appear to even be possible that this is a matter of some sort of small oversight. Those things just don't add up in terms of what we saw and learned today. So Mr. Gordonier appears to have this event in terms of something not being correct with the way his tether operated. There was no alcohol detected. As far as we know, Mr. Hayes indicated that we don't know whether or not there would have been any because the device doesn't function properly when these sort of interferences occur. But I think both Mr. Hayes and Agent Levitt indicated that Mr. Gordonier has not had any problems other than this one incident. And that may be something said to his credit, in addition to the fact that it makes it even less likely that this event was something sort of coincidental, because I think it goes to how difficult it is to produce evidence of a tamper to this extent. So with that, the people would ask that the court accept that testimony and find Mr. Gordonier in violation.
Thank you. Ms. White?
Yes, Your Honor. This was a one-time event, but Mr. Gordonier did go in several times because of the device being loose.
We have no evidence of that, Ms. White.
That is true, and I did try to get Community Corrections. Unfortunately, they did not have record of it. Mr. Gordonier says that his work boots.
He can't testify here today. unless he takes the stand. That information is not before the court.
Okay. I do believe that the device could be loose. Oh,
All right, we need to stop for a moment.
okay.
All right, you may proceed.
I do believe that the device could be loose. I don't think that was disputed. I don't think nothing can be 100% correct. They did say that when it is loose, they do try to adjust it. And that sometimes the notes aren't put in there. I do believe that in this case that it was just loose, and the time period is overnight for the most part, so that it could have moved around. And I hope that the court will take into consideration. Thank you.
Thank you. The argument that this could be loose was absolutely disputed by Mr. Hayes. Mr. Hayes indicated that if it was loose, the actual reflectivity level on the actual chart would go down and not up. And therefore, there was no evidence to show that it was loose. In fact, it was the opposite. It shows that it was not loose. So the expert in this particular case, Mr. Hayes, testified as to why it was found that there was a tamper. The court has reviewed the documentation and can see here that there was the background highlighted yellow portion of this that shows that it was, in fact, a tamper event. His testimony went even further to say that defendants are given an opportunity by looking at the graph to see whether or not there is just one point of actual change in the actual IR voltage baseline or a number of changes. In fact, it is not considered a tamper event if there is no alcohol detected unless it's longer than 8 hours. This event was 10 hours. Therefore, I find that there was actually, in fact, a tamper. My real concern here is, people make mistakes. They mess up. They have infractions. They do the wrong thing. And we have that happen all the time. When people accept responsibility for it, this court views that one way. This court is willing to give people second opportunities. But when people don't accept responsibility for their actions and they require that it has to be proved, it is viewed very differently. So, having found that there is a violation in this case, bond in this case is revoked. Please turn yourself into the Washington County Jail, sir.
Ma'am,
Your Honor, may
All
I
right.
speak?
yes, ma'am.
May I speak on his behalf on that?
You did. You had a hearing.
Thank you.
I didn't knowingly tamper with anything. I didn't do anything. Am
In
I,
this matter, I'm going to schedule the next, well, actually, what I'm going to do, sir, is I'm going to issue a bench warrant. We'll address this issue when you get brought before the court. We'll give you a new court date.
so will I be sitting in jail until my hearing? Until I'm sentenced?
You'll be sitting in jail until you get heard before the magistrate, sir. Okay?
Well, what I'm asking is there's no way I'll be able to be released back out on bond until my next date? I mean, or until I'm sentenced?
Sir, I've
Yes, sir.
told you what's going to happen next.
I
You need-
didn't understand. That's why I was asking.
Because you don't get to ask me what happens next,
I'm
other
s-
than yourself in.
I
Okay?
will, ma'am. I
All
will.
right, thank you.
And Your Honor, just, I think that Mr. Lebo may have covered this case at some point because I see language about an assessment here, which wasn't going to matter. There were no offers on this case. This is a high BAC. And so there have been some previous adjournments with discussion of or Mr. Bellinger even. And so just so it's clear, the posture of the pretrial is that there are no offers, so Mr. Gordinier can plead or go to trial on it. But we're not waiting on anything for the pretrial.
Thank you. Bench warrant to issue, no bond. Yes.